Hi, good afternoon. This is attorney Kathleen Scott. I'm the managing partner at the Scott Wagner Law Firm, and this is our webinar. We're continuing to bring you information for your practices. This is a coronavirus and healthcare provider professional update. Again, this is Kathleen Scott, and in this video, we're going to be covering three main topics. We're going to be talking about healthcare employee rights and helping employers comply with all the issues that they need to during this critical time during this corona and COVID-19 outbreak. We're also going to be talking about the ever popular PPE protective material to help keep healthcare providers safe. And lastly, we're going to cover a little bit about the telemedicine and the new relaxation of those policies and procedure. And so I just want to make sure everybody's ready to go. I'm waiting for my sound to give me the cue that everybody's can see and hear me fine. If there's any issues, you can feel free to let us know by posting up on our page. Okay, why don't we get started? So first question that we've been asked a lot is, do employees have to report to work to their healthcare providers? And that is an important question, and one that I've been receiving it quite regularly, both from employees and employers alike. And as many things in the law, then you can usually answer it with "it depends." So it's not unlike other things. It depends. I'm now getting an email that perhaps the live hasn't started. Let me just hang 10, everybody. Okay, so the answer to the question, which is, do your employees have to report to work to a healthcare provider? The answer is yes, if they are considered, the employer is considered an essential business. So let's go through the analysis about what an essential business is. So an essential business is someone who has a certain area that is at a stay at home. So as all of you know, that several states, as of March 25th, and this is a moving target, have issued a number of stay at home orders. We are under a partial one here in Florida, but on your screen is a number of states who have gone to a stay at home order. So let's break it down, look at a map in place. There are a number, this is complimentary of the New York Times, so thank you very much. This is a map that shows you shaded in the orange, completely blacked out, is a statewide order. Portions of the state are, in the state of Florida, for example, where I am, have a stay-at-home or a shelter in place, a partial order. Why is that important if you're a healthcare provider? Because those orders typically don't apply if you're considered to be an essential business, meaning you can allow your business to keep operating. So let's go through it. What is an essential business? Well, a business is essential, is determined by your state and local government. So it is different for every single person depending on where you live. I'm in Palm Beach County, Florida, so it's different for me than somebody who might be, say, in Martin County, Florida. And you have to take a look at what has been issued. So for example, in Palm Beach County, I have a mayor in my hometown here of Jupiter, but I also have the Palm Beach County mayor, which is somebody who can issue an order that can define what is essential and not essential. In other states like California, there's a complete stay-at-home shelter-in-place order in effect, which can make it more detailed. So essential businesses under Department of Homeland Security guidelines, some individuals fall under these. Whether or not your company is considered to be a healthcare operation, that would be considered essential. Infrastructure like power generation, fuel supplies, airports, transportation, that can be considered essential. Manufacturing, this is particularly true for manufacturers who are manufacturing healthcare necessities like masks and those 95 masks that we keep hearing about in the news. Retail in part could be essential if the retail establishment is a grocery store that's providing food, a pharmacy that's providing medication. Convenience stores could be, depending on what they are providing. Liquor stores, probably not, although that's probably up for argument by many who are under a shelter-at-home order. Restaurants and bars in our state are open, but only for takeout. It's kind of been a slow reduction. First it was only 50% capacity, and now it's takeout only. And so essential businesses, it's a very much a moving target. The takeaway here is it depends. You should consult both your county and your city, because those two orders might be different. So we start big, we start with what the governor has said. The governor's order is to follow the CDC guidelines, which have said, no gatherings more than 10. and don't go out unless you need to go out. There are more restrictive guidelines in place, like in Miami-Dade, with restaurants and shelter-in-place orders in Palm Beach County. Those things are expected to intensify in the coming days. So stay tuned to the news media. Also, let's discuss what is an essential business under the Department of Homeland Security for some other types of businesses like news media. That is, in fact, an essential business. Some financial institutions like banks need to be open. Construction, possibly. There are some individual companies that we've advised are an essential business. Those that provide air conditioning services, by way of example, here in Florida, you could make a strong argument that that is essential. Law enforcement, those types of things. So what if your particular business is not covered, but you think that the kinds of things that you're providing might be essential? We can make that argument with our law firm. We are lawyers, as employment lawyers, may not be considered an essential business, but as we're helping individuals and entities kind of navigate through what rights and obligations they have to employees during this period of time, you could make that argument. That too is like an essential business. Some states will allow you to apply for a relief or waiver. Other states it's on a case-by-case basis. Florida does not have any particular waiver policy or plan set up. So the question we've been asked is, well, do essential businesses need to have some type of certification? And the answer is probably not, unless you're in some states like New York. We're here in Florida. We don't have that requirement here locally. So that's one less thing to worry about. This issue about whether an employee has to come to work when they're in a shelter-in-place order and whether or not they work for an essential business like a healthcare provider, which is the focus of today's talk, is very important, because if you terminate employees for refusing to come to work, then you could be potentially liable as the employer for what's called whistleblowing. Whistleblowing is something when an employee comes and says, I reject doing this because I think it's a violation of the law, and then the employer says, well, if you don't do it, you're fired. Terminating that employee under those circumstances could be considered blowing a wrongful discharge case to the extent that employee has blown the whistle. And my colleague, thank you, Ms. Wagner, just pointed out that Palm Beach County does define in their ordinance law firms as an essential business. So all of those working for law firms, we just want to make that quick notation. So as it relates to the public, as it relates to the topic of today's healthcare providers, we want to talk about what does it mean to run a healthcare provider organization and comply with both keeping your employees safe and allowing people to come into work feeling safe and remaining open to the public to serve the public. And so obviously social distancing has become a very popular thing, and allowing employees to work at a safe distance from each other. And that's not just a good idea, it's actually required by county ordinance in some places like Miami-Dade, and that is the emergency order 7-20, which specifically replies limit the number of persons who may be physically present. This is all an intent to keep employees safe and healthy, and also to keep businesses functioning and being able to serve the people who need to be served right now, like healthcare providers. And in other states and counties like Los Angeles County, California, essential businesses that remain open have to allow access to hand washing facilities using soap, water, and sanitizer, assuming that they can get some. Also posting signs in conspicuous places at the public entry, letting members of the public know that they should not come in if they're experiencing symptoms or respiratory illness, fever, or cough. In Florida, we have a unique order too for our restaurants are required to ask employees if they've been exposed to anyone who is sick in the last 14 days, if they've traveled in the last 14 days, if they themselves have had symptoms and they need to self-quarantine for 14 days. And so those are the types of things that essential businesses who are going to stay open during this difficult time need to be practicing, making sure they're keeping not only themselves safe, but also the safety to the public. So if I am not an essential business, can I remain open? And the answer is yes, if you can telecommute. So there's no prohibition against working and earning money if you can do so from your home, telecommuting into a server, working remotely, cloud-based working. All of that is perfectly allowed under the even shelter-in-place orders. There's no prohibition against making money or earning a living. It's only against going outside and sharing what could be potentially contagious behavior. And so that's what these laws are focused on preventing. All right, so let's talk a little bit about Florida. Florida Executive Order 2072. This is specifically tailored to healthcare providers. And what it does is it prohibits medically unnecessary, non-urgent, or non-emergency procedures or surgeries to take place during this COVID-19 outbreak. So if you have scheduled a non-elective surgery, or if you need to have your teeth cleaned, or if you're going for a regular checkup, those things are typically going to be considered medically unnecessary, obviously at the advice of your doctor, but those are not the kinds of things that should be taking place right now. The idea is to limit the number of people coming into healthcare providers, but healthcare providers can stay open. So here's a little closer look at the state of Florida executive order that specifically relates to healthcare providers. So a state of emergency was declared, and that's significant. That's where the origin of the power comes from to be able to issue these types of guidance. So pharmacists can give 30-day emergency prescription refills. So someone always asked the question recently, well, I need an inhaler and I can't go to the doctor to get a script. That's the type of thing a pharmacist could offer, a 30-day automatic emergency prescription under these states of emergencies that we're in now. So that's good news to all the asthma sufferers out there. So non-Florida medical professionals, social workers, counselors, and those with valid licenses from outside of the state of Florida are allowed to come into the state to help us through this difficult time, to render free medical services if they do so through the American Red Cross or through the Florida Department of Health. So essentially we're relaxing the restrictions on practicing of medicine and healthcare provider during this crisis to allow us to get the maximum number of healthcare providers here to help service Palm Beach County, which is being targeted as a pretty tough area. Another aspect of this relates to hospitals, ambulatory services, surgical centers, office surgery cells, dental offices, orthodontics, endodontic offices, and other healthcare practitioners in Florida are prohibited from any medically unnecessary, non-urgent, or non-emergency procedure. So for all my dentist clients out there, are you allowed to stay open? Yes, but you're not to be open to just do cleanings, not to be open for just regular exams or x-rays. You need to be open for emergency-like situations. There is a little bit of rub about what an emergency might mean. So I think there's reasonable minds can disagree on this, but in general, an emergency procedure is something that if it's not addressed could have potential life-threatening effect. If it's not addressed, could have potential extreme pain or discomfort or cause issues. So I think using that as a guideline, many dental offices can stay open for emergency procedures. Some are viewing it as just pain management, and there are some reasonable minds can differ as to whether they're allowed to do more significant procedures than that. So people who are arriving for health response are not subject to any type of the state 14-day self-quarantine isolation. Let's talk about that. So there's currently a domestic ban. If you're flying in from either New York, New Jersey, Connecticut into the state of Florida, you must self-quarantine for 14 days. There is a relaxation of that requirement for people who are coming here to help serve the healthcare response. So workers, healthcare workers, that type of thing. So that's helpful to know. So critical businesses are allowed to stay open, but they may be subject to other state or federal orders. I gave the example earlier about restaurants are considered to be an essential business and they're allowed to stay open, but they have to practice social distancing and they need to ask their employees those questions that we talked about. Has anyone in your household traveled, been exposed to symptoms? Are you yourself having symptoms? So there's a little bit of a higher onus on the employer to make sure the people who are coming into the workplace are safe. So critical businesses that can remain open are listed on this screen. We can go through some of them: hospitals, doctors' offices, urgent cares, of course, physical therapy offices, substance abuse providers, pharmacies, research and labs can stay open, blood banks, even medical cannabis facilities are deemed to be an essential office which can remain open. So what if a business chooses to stay open even though they're not defined on that list as an essential business? They can be exposed to citations, to fines, to licensing, to even criminal penalties. That would include being imprisoned, which would not be a very good time to be imprisoned. Although there are some states like California that have tried to incentivize employers to comply with these orders. So they're, just stay tuned. In Florida, we're not seeing a lot of police action yet. This crisis is really just getting started, from my understanding. Okay, so let's talk about employee rights. So you're an employee, you work for a healthcare provider, you're just not comfortable coming in because you're concerned about being exposed to COVID-19. I am married to an emergency room physician who goes into the ER, so I understand that fear is real. It's certainly, so what the question here is, what does the law say? Do you have to come into work? And the answer is no, but if you're just not coming in because you have a personal concern, then your rights are not protected, meaning if the employer chooses to terminate your employment, then you're not going to have a claim for wrongful discharge. So employers, you have a right to demand that employees for your essential business, your healthcare provider company, if they are uncomfortable coming in, they have the right not to come in. Of course, you can't force them to come into work, but as the employer, you also have the right to either discipline or dole out coaching activity to encourage them to do so. Now, we'll talk a little bit later about whether they might be entitled to family leave, but in this scenario, my hypothetical, where they're just uncomfortable coming in because of personal concerns for their safety, that's not going to be enough. Now, where this becomes a little bit more of an interesting question is, what if the healthcare provider worker is refusing to come into work because of their personal safety, because there are insufficient medical procedures in place, there are not enough masks to protect them, there's not enough PPE? Well, then their concern becomes more than just a personal concern. That becomes a health, safety, physical risk concern. And I think that would be a different scenario. So if an employee is refusing to come in because they don't have a clean mask to use, terminating them in that situation could be a potential violation of the law and a wrongful discharge case. What if the employee is not coming into work because they need to stay home to take care of their children whose schools or daycares have been closed, or their child care provider is no longer available? As healthcare providers, you may be obligated to provide them with family medical leave, and that leave might be paid leave depending on the scenario. So let's walk through it. Last Wednesday, the Congress passed and the President signed into law an emergency extension of the Family and Medical Leave Act. So historically, in 1993, President Clinton signed the FMLA, as it's often referred to, into law. That law, as it was enacted, only applied to employers that had 50 or more employees. As of Wednesday of last week, the law now applies to all employers who have less than 500 employees. So if you're a healthcare provider and you have less than 500 employees, this law may apply to you. And essentially, but it's not all bad news. So there's a couple of things that we need to know. One is this law only applies from April 2nd until the end of the year. So it's a short compliance time. It's during this COVID-19 outbreak. That's one point. The second point is there's only one circumstance that the law requires that you comply with if you have less than 50 employees. And that circumstance is if the employee is unable to come to work because they're home taking care of children whose schools are closed or daycares are closed or lost their child care provider due to COVID-19. And that one limited scenario, then you healthcare providers need to provide paid family leave. Now, there might be an exemption to whether or not might be an exemption for that particular scenario. But the Secretary of Labor has to identify whether or not the employer has, quote, good cause to meet the elements of the exemption. So the law does say that the Secretary of Labor could find good cause to exclude certain healthcare providers and certain emergency responders from the definition and from the statute altogether. But at this point, we don't have any guidance on that. So the guidance is due out today. I checked before this presentation began. It hasn't come out yet. So the takeaway here is to healthcare providers and all employers out there who have less than 500 employees, less than 50 employees, you might be exempt. But until we have the Department of Labor's guidance on who's going to fall into those exemptions, the safest course of action is to comply with this Family Medical Leave Act. And again, only applies if an employee's home and can't work because their school's closed and they have to take care of their kids, or daycare is closed, or their child care provider is no longer available. In the situation that the Secretary of Labor does finally get to the guidance and issues those guidance, then the exemption is going to circle around who's a healthcare provider that's exempt. And second, businesses that have less than 50 employees might be exempt if they can demonstrate that complying with this paid family leave would jeopardize the viability of their business. So we don't know what that's going to look like yet. So again, the safest course is to govern yourself as though this applies until you understand the exemptions and can determine whether or not those exemptions apply to you. Okay, so what if the law does apply? Who does it apply to? It's employees who've worked for you for the last 30 days. So the original FMLA, you had to be there a year, you had to work so many hours, there had to be 50 or more employees. This Emergency Act relaxes those standards and applies this family leave to individuals who just have only been working for 30 days. That's important to remember. And so I put up on the screen here, this is the actual language of the statute that indicates that it's an emergency expansion of the Family Medical Leave Act of 1993, as we talked about, that it's qualifying because as a result of this public health emergency. And let's look at the language that talks about what you have to do. You have to offer paid leave for taking care of small children. A little caveat, we're just talking about the Emergency Expansion Act in this presentation. So if you're an employer that already has 50 or more employees, you've been complying with the FMLA probably since 1993. Those don't go away. You still have to comply with it. What we're doing is just adding additional categories of employees who might now be qualified. And so a lot of healthcare providers are kind of getting this wrong because it's confusing. The questions I'm being asked are, well, nobody's sick, so unless they're sick, I don't have to pay them to stay home. No, whether or not they're sick does not govern whether this paid leave kicks in. The paid leave kicks in. Here's the language right up on your screen. Paid leave kicks in if the employee is unable to work due to need to care for their son or daughter under 18 years old, if the school is closed, if child care provider is not available, and that's all due to COVID-19, this public health emergency. Those are very specific. So it says son or daughter, does not say stepson or daughter. So I think that's an important distinction. It doesn't say brother or sister, it says son or daughter. It doesn't say niece or nephew or granddaughter. So those are some distinctions that we need to make sure we're paying attention to as we try to comply with this. Okay, so if you do have to comply with the paid family leave, how much does it cost? Here's how it works. The first 10 days, unpaid. So employee goes out, daughter's school closes, has to be home with the daughter, of course. First 10 days are unpaid. If that employee has a bank of sick or PTO time that they've saved up, they're allowed to use that to make it paid for those first 10 days. That's at the employee's election. That is not for the employer to decide, that's for the employee to choose. So they can substitute that to make it paid. Great. The next period of time after that, the employer is obligated to pay 2/3 of that employee's salary, up to $200 per day. So, or $10,000 in the aggregate. So essentially the remaining 10 weeks after the first 2 weeks, which can be unpaid, are going to be $10,000. 200 a day times the next 10 weeks is $10,000. That's how the statute gets to that number. So first 10 days unpaid, up to 10 weeks after, $200 a day, or $10,000 in the aggregate per employee. That's expensive. Keep in mind though that the employee has to keep qualifying for this leave. So if at any time the schools reopen, the obligation ends. If at any time a second child care provider becomes available, there's an argument that the entitlement may end. So keep that in mind. So just a quick little chart just to say what I said. First day, 1 through 10 of the leave is unpaid unless there's PTO to fill in the blanks. Then thereafter, the employer has to pay up to $200 per day for a maximum of 10 weeks, provided that the employee continues to qualify for the paid family leave. Note that there's no requirement that you offer paid leave in the event that the employee themselves is sick. I just want to say that again because that is, kind of a little bit counterintuitive. This is family leave. This isn't personal sick leave time. The law also requires that there be a right to reinstatement, and the reinstatement is dependent on certain criteria. And so what reinstatement means is bringing back the employee to their regular job. It has to be nearly identical. The language from the statute is you must restore the employee to an equivalent position with the same benefits, pay, and other terms of employment. So that it can't be that you bring somebody back because they've taken leave and now they're going to be demoted or suffer some type of pay loss. That doesn't work. It has to be apples to apples, bring them back in the same position. Okay. There are certain exemptions to reinstatement. The law writes in an exemption if you have less than 25 employees and you meet all of the 4 criteria, you do not have to keep the position available. And the criteria is that 1, leave was taken pursuant to this COVID-19 crisis. Number 2, that employee's position no longer exists. Let's say you've laid off a particular category of employment. 3, you have to make efforts to try to place that employee whose position was laid off into a different position. And last, you have to continue to reach out to that employee for up to 1 year after they've started their leave to see if they can be placed in another position. So assuming you meet all of those exceptions, you have less than 25 employees, there may be no obligation to reinstatement. The law also requires that all employers with less than 500 employees must post a notice in their workplace, giving as much notice as possible to employees, letting them know what these new laws entail, letting them know they might be entitled to family leave. There's some sick leave obligations that don't apply to healthcare providers. And third, letting them know what their rights are for unemployment compensation. The language of the notice is due out today by the Department of Labor. It will be up on our website for everyone to see. I would encourage all employers to post it as soon as possible and post it in every language that's applicable to your workplace. And the Department of Labor is usually really good about bringing those notices up in common languages like Spanish and Creole. All right. Here's what you need to know about the unemployment compensation. Now, this does not include what happened last night because we're still waiting on the final bill for that and for it to be signed into law and to be codified. So what I'm talking about with this unemployment is the unemployment bill that passed last Wednesday. What that law requires employers to do is simply, if you're going to lay off employees, you need to tell them that they might qualify for unemployment and then direct them to that state's website. At Florida, it's the floridajobs.gov website. Doing that will comply with your obligations under that statute. So a little bit of good news. It sounds like this family leave is going to be really expensive. Healthcare providers are trying to do what they can to stay in business. So how are they going to pay for all of this paid leave time? Well, they get a tax credit back, and here's how it works. So if you're an employer and you've paid out $2,000 in this paid family leave because your employee's home taking care of their child whose school is closed, but then when you go to file your second quarter tax return, also known as a 941 report, you're going to owe a certain amount of tax to the Department of Revenue. And instead of paying that tax, you're going to get a credit for however much you've paid, dollar for dollar. It's a 100% credit for any paid sick leave. So that's how that works. The other little benefit is under the tax code, the paid sick leave is not considered to be a wage, which means you don't have to pay payroll taxes on it. So this again takes place after April 2nd, and then it continues until the end of the year. So that's a little tip that you get a little tax credit for that. Now here are some practical considerations. So a lot of employers are asking me, well, if this law doesn't take place until April 2nd, should I wait till after April 2nd to pay this family leave, or will I not get the tax credit? Based on the language of the statute, that would appear to be true. Of course, we're still getting in guidance. We're still waiting for the Department of Labor to issue guidance. That would be the safest course of action. I am not saying that in no circumstance paying it earlier would result in not getting the credit, but there's no indication that that's the case yet. So the safest course of action might be to wait to pay that out until after April 2nd. I know that families need money, but but trying to look at it from all angles, that's the law. I'm reading the letter of the law. That's the issue. There are some loan restrictions. So several counties, including Palm Beach County, the state of Florida, and the Small Business Association have issued loans. At least one of those loans have a restriction on it that you can't get access to that loan unless you've kept 90% of your employees on staff. So that may be something that you want to think about practically. A lot of employers are thinking about laying off people, particularly before this law takes place, because they're like, how am I going to afford to pay family leave when my income's down and business is down, and they're worried about existing. So the government is trying to incentivize them to keep their workforce as full as possible. In an effort to do that, they're offering them loan incentives. All right, remote workers. So if you're able to have your employees work remotely, that's great. But let me just give you a couple things to think about. Make sure you know what device your employees are going to be remote accessing from. Are they using their own laptop? Are they using their own personal computer? Are they using a workplace computer? If they're using their own computer, you need to be sensitive to the fact that they might be downloading your company's data on their personal device. We call it the BYOD. It's not a keg party, it's a bring your own device party. If you're bringing your own device to use to work remotely, the employer needs to have some type of policy that protects that data. Make sure that they have access to it post-separation, to make sure that you have the proper firewalls in place, that you can't just have that data being damaged in some way or being open to the public. So that's something that's important for all employers to think about. Also, there might be some Americans with Disability accommodation concerns just to think about. The longer an employee is allowed to work remotely, the more like a permanent type of accommodation that starts to feel like. So if you're an employer and you're allowing your employees to work remotely during this crisis, you might think about making it specific so they understand that this is just a temporary accommodation. We're not moving to a remote workforce for long term. This is just due to COVID-19. Because failure to do so may create the presumption that this is going to be an ongoing type of accommodation. Also, it's important to define the number of hours that you can work each day and track those hours. Overtime is based on a 40-hour work week. And so some employees, when you work remotely, you can almost work all day, right? Like you get up, have a cup of coffee, sit down at your computer, and it's 7 a.m. and the next thing you know, you've worked a full day and you just keep going. So if employers are not wanting to pay the overtime, they need to tell employees on the front end, be proactive, what the expectation is for a work day, and to make considerations for overtime. All right, so how do we handle sick employees? Obviously, we want to focus on social distancing and talking points for managers to make sure that they understand it's nobody's fault. We want to just keep a distance. The best advice is to act like you yourself have the virus in the workplace, so therefore you can't spread it to others. 6 feet is what the recommended social distancing is. For healthcare providers, you need to go a step further and make sure that you have all available masks and shields and gloves, hand sanitizer, and a place for employees to wash their hands regularly, and make sure that you're enforcing that. What if an employee gets COVID-19 in the workplace? Well, there's 2 things to think about. This is for healthcare providers, this is for all employers. It might be a recordable event for OSHA purposes, and it may also be a workers' compensation claim. So let's walk through how to handle those. So for an employee who contracts COVID-19 at the workplace, then it might fall into one of the work-related criteria and the regulations, and therefore it's a reportable event. I'm putting up the OSHA guidelines that you can click on. It will take you directly to that to find out if that is a reportable event or not. So OSHA has kind of a personal protective equipment standard, which requires the use of gloves, eye protection, face protection, and respiratory protection. So if you get sick because those are lacking, that is a recordable OSHA event. Healthcare providers, this applies to you primarily. That is something you do need to report to OSHA. There's also a general duty clause, which requires employers to furnish workers with sufficient information to keep them free from hazards. So if the employer doesn't have enough gloves, doesn't have enough protective gear, they need to give some thought to how they're going to handle that, because that's going to create an OSHA recordable event as well. All right, so workers' comp is a little bit of a trickier question. Is getting COVID-19, contracting it at the workplace, a workers' compensation injury? And the answer is, it depends. So in Florida, generally it wouldn't be considered one, and the way that we look at that is we define whether there was an accident or an exposure or an occupational disease, and the standard for whether that meets those requirements is whether or not the COVID-19 was contracted by an employee who's at a greater risk than the risk that was faced by the general public. So if I go to my workplace at the law firm, I'm pretty much at the same risk as everybody else. But if I go to work at a healthcare provider, if I go to work at the emergency room or urgent care, I'm at a higher risk than, say, the general public. So I think there's an argument there that this might be covered by workers' compensation if an employee gets COVID-19 while at the workplace working for a healthcare provider. If you're the employer, no need to panic about that uncertainty. Just report it. Report it and file the claim. That's the safest thing to do. And leave it to a later date for the employee to see if they can prove by clear and convincing evidence that it was caused by the workplace or not. That's not something that has to be decided today. That's just something you just need to file the claim and move on. For employees, same thing. Just report it as if you would report any injury, and then that's something for a later date to figure out whether it's going to be covered by workers' comp or not. Hopefully it's going to be like it's supposed to be for 80% of the population, very minor cold, perhaps flu-like symptoms, and then move on. All right, so next we're talking about how we have to stop non-essential elective medical procedures. I talked about this in the beginning, but it's worth reiterating. This is the Executive Order 20-72, which defines what is an essential versus what is an elective medical procedure. So certain things should be delayed if doing so may not cause a problem. So here are some permissible procedures, meaning you're allowed to do these. CMS includes removal of a tumor, for example, transplant, limb-threatening vascular surgeries, trauma procedures, dental care if it's related to the relief of pain management of the infection. That's a new guidance that didn't exist with the original executive order, so that's important for my dentist clients out there. Pain is going to be something you need to well document if you're going to do a procedure in your medical provider, that you're doing this to relieve pain. That's an important example. Last thing to talk about is telehealth. So there's been a lot of back and forth in the state of Florida whether telehealth is a good idea or a bad idea. And telehealth simply means that you're using an iPad or the internet to communicate with your healthcare provider. You're not having an in-person consultation. So Florida had some pretty stern regulations on that, although we were moving in the direction of relaxing them. But during this crisis, the Office of Civil Rights, or the OCR, at the Department of Health and Human Services, which is a federal agency, they're the ones that are responsible for certain regulations as it relates to HIPAA, protecting our healthcare information, as it relates to these telehealth. So, but effective immediately, the Department of Civil Rights is exercising its enforcement discretion to not impose penalties for any HIPAA violations in order to allow good faith telehealth to proceed forward. So that's good news. So if healthcare providers who are trying to reduce the risk of their employees' exposures and to offer more services to more sick individuals may use telehealth as an option, and don't have to worry about the compliance. Don't have to worry about whether or not what they're doing violates HIPAA. Of course, the healthcare provider still must take all appropriate safeguards to protect the data as they would, but using telemedicine in and of itself is not going to be deemed a HIPAA violation as it relates to the treatment of COVID-19. So that's good. So let's talk about some examples. A covered healthcare provider, in their exercise of their professional judgment, may, number one, request to examine a patient exhibiting COVID-19 symptoms by video chat, which is an application connecting that provider or patient to a desktop or phone or laptop or something of those means. Number two, the provider can use their professional judgment to access or treat any other medical condition, even if it's not related to COVID-19, like a sprained ankle or looking at their tooth or psychological evaluation or other conditions. So those are going to be allowed now for telemedicine. The guidance has just come out that there are certain platforms that are permissible, and that includes Apple, FaceTime, Facebook Messenger, video chat, Google Hangouts, Skype. And so providers are encouraged to notify patients that these third-party applications potentially introduce privacy risks, and providers should enable all available encryption and privacy modes to the extent they're available. They also need to tell their patients it's not foolproof. There are certain things that have been deemed not permitted for telemedicine platforms. That's this platform we're using right now, Facebook Live, Twitch, TikTok, and other communications that are public facing and they should not be used for telehealth. Obviously, you don't want to be broadcasting personal health data, personal health information, PHI, out to the public. So those are the platforms. So HIPAA compliant video communication products include the following. I have a list up on the screen. You'll see Amazon Chime, GoToMeeting, Skype, Zoom, Doxy.me. And finally, there's a little summary of all the telemedicine services as it relates to Medicare. So these are not things that we need to go over in great detail, but things I did want to put up on the screen for you to take a look at if you do treat a Medicare population. These are the types of telecommunication you can do. So we covered a lot in a short amount of time. I've gone over the allotted time just a little bit. If you have questions, as always, at the Scott Wagner Law Firm, I am board certified labor and employment lawyer. We also have a healthcare practice, so we're really here to help address your concerns and help everybody stay healthy and well and compliant with all these new guidelines as they come out. I should mention that as we were doing this seminar, I can see that my computer is lighting up with some guidelines that are coming down from the Department of Labor, as well as some codification of the bill that was passed late last night. And so these things are a moving target. As we get more information, you should stay tuned to our Facebook page, the Scott Wagner page, also our website, which is scottwagnerlaw.com or floridalaborlawyer.com. We're going to be updating regularly. We'll continue to do these Facebook Live videos. I would encourage anybody who has questions to send us either a secure message or to post it if it's nothing that's super private on the Facebook page, and I'll answer it. It's a good thing if you're thinking about it, other people may have the same question too. So stay well, everyone, and we'll be back in touch with some more information soon.